And we do have participants, of course. I am willing to bet Bob and Jamie's in there. Okay.
So did George stop at Jaime's office first to see if he can join there, and then decide to go to Bob's house? Or
I actually ended up sick.
oh, I'm sorry.
So I had to go home yesterday, and I'm still home today, and I'm in the midst of the COVID testing phase.
Oh boy.
So I wasn't able to do the in-office thing today.
Yeah.
So we made alternative arrangements.
Yep. Of Dee's laptop. Is Dee's laptop? Do we think that that's Bob?
Who knows?
Dee's laptop.
Why don't we ask Bob, whoever is Bob, to raise his hand?
Of Gretchen Metzloff.
That doesn't seem right.
Dee's laptop. Can you let us know who you are? Dee Lipka. Okay, fantastic. All right, so I'm gonna move you back to the other side.
Oh, okay.
And what happened?
Mark or Amanda, did we adjourn or close public hearing on Birch?
I'm pretty sure. Hold on, let me check. Probably adjourn.
We adjourned.
Yes.
Yeah, probably adjourned. And yes, we adjourned it.
Thank you for answering all of my questions. I have another one. When we're talking about substantial or not substantial for a requested variance, what specifically is that referring to? The percentage? No.
I mean, it can, it's certainly
Is it subjective?
Yeah, it's subjective, but it's more about impacts. You know, is it substantial when you consider impacts of the variance on neighbors, the neighborhood, etc.?
So with percentage of neighbors coming in to respond in the negative about a request, that could fall under the substantial category in terms of effects?
Possibly.
I want to save speaking this time and not talk as much.
If you want to talk more about any of the factors and the analysis you would need to do, that's probably something that you and I should talk offline about, you know, like attorney-client.
You are willing to, then in the future, I would love to do that.
Yes, sure. We have George and we have Bob. Hello, hello. You guys are muted.
Hello.
Okay.
Are we ready to be on?
We are recording. Yep, we have quorum now that you guys are here.
Oh, good. So it's time to start the meeting.
Mm-hmm.
Okay. Good evening and welcome to the Village of Ossining Zoning Board of Appeals regular meeting of November 9th, 2021. Notwithstanding the provisions of Article 7 of the Public Officers Law to the contrary, this meeting is being conducted remotely in accordance to the Chapter 417 of the laws of 2021 in light of the public health and safety concerns associated with the COVID-19 pandemic. There is no public participation in person tonight. Rather, the public can watch the live meeting online through Zoom. Notice of tonight's meeting was published as required and posted on the village website. The web notice included instructions for members of the public to access the meeting and participate in any public hearings. Comments will only be taken during the public hearing portions of the meeting as usual. In order to participate, please do the following. Members of the public attending online via the Zoom app may use the raise hand feature at the appropriate time if you would like to make a comment. That feature is located at the bottom of the screen. Those attending via telephone can press *9. The meeting host will see that your hand is raised or that you've pressed *9 and will unmute those waiting one at a time so that you can speak. Lastly, comments can be emailed during the meeting to J Martinez, MARTINEZ, at villageofossining.org. So Jaime will take those emails and they'll get them on the record. Any written comments will be written into the record, as I just said. Please note that tonight's meeting is being recorded and a video and transcript will also be provided at a later date on the village website. Ground rules. In order to keep this meeting orderly and ensure we get a clear recording, please follow these ground rules. When you are given access to speak, state your name and address. If you are speaking during the public hearing, please limit your comments to the matter which is the subject of the hearing. Board members, please mute yourselves when not speaking. Also, board members, I will call on you one at a time to speak to avoid everyone speaking at once. If you wish to speak at any time when I'm not calling on you, you may also use the raise hand function or literally raise your hand so I can see you and call on you. We will use roll call voting for all purposes of board motions. This is to ensure that the record is clear. Thank you to everyone for their patience as we continue to conduct remote meetings. Roll call. For the benefit of the record, we are going to do a roll call to kick things off. When I say your name, please indicate that you're present. Bob DeRio, acting chair, that's me. George Bailing. Here. Kyle Beckley.
Here.
George Gorensky.
Oh, here. Okay.
Mark Gorensky, sorry. Yeah. Okay. And for the staff that's here, Joseph Agustinelli, he's our building inspector. Jaime Martinez, our planning director. Jamie Kane, our board secretary. And Amanda Brosi, who is the village land use attorney. And thank you all for being here tonight. So before we do anything else, I just would like to make mention that the reason I'm sharing this meeting tonight is Marlene Cheatham, our illustrious chair, her mom passed away. And so she's dealing with that. And we are all keeping her in our thoughts and prayers at this difficult time. On that note, I believe it's time to look at the agenda. Yes? Okay. Continuing business of the board, ZBA 14-2021, 19 Birch Court. This is an area variance for a side yard setback. If Jaime would not mind, he can give the board an update on where this is. I believe we're going to have this administratively adjourned because they didn't get their revisions in by the deadline for this meeting. Is that correct, Jaime?
You stole my thunder, yeah, so.
Oh,
That's right.
so
So the applicant has submitted some materials, but they didn't submit them in time for them to meet the revision deadline. And so they have been administratively adjourned to the following month.
oh, cool beans. New business of the board. ZBA 21-19, 81-89, South Highland, Birch Brook. Well, this is a request for an extension of area variance for the minimum lot area per dwelling unit. I'm going to ask Jaime to describe the application to the board and give an update.
Yeah, so the 8189 South Highland Avenue, Birch Brook Manor is a subdivision that would yield 5 new units on the back of the property. So the new property is actually going to be, I'm drawing a blank on the road here, Ogden Rd. And so the new property essentially has to go through a multi-step process. Originally, it had to go through site plan review, subdivision, preliminary subdivision approval. Then it had to go to the Department of Health for approval of the connections to the sewer system. Now it's coming back for a wetlands permit and final subdivision approval. It had to receive some extension, some variances to make that project move forward. And so as the extensions need to be amended, have to be extended every 6 months. And this process started some time ago. With the original approvals, I think dating all the way back to October 2019. They're in here for what I believe is the 4th extension, as they are looking to close out the work on the planning board side, theoretically next month or the following month after that. So, so that's where we are.
Okay. If the applicant's team is here, can we ask them if they have anything to add? And if so, they should keep their comments to 5 minutes or less.
We do have some people from the applicant. So let me just pull that up. We have Alec Glad. Alec, if you could turn on your.
Thank you. Paul Glad from Cuddy and Fader. I don't have much else to add. That was a nice summary. We opened the public hearing before the planning board on the wetland permit and final subdivision approval. It got adjourned to later this month. And the only kind of outstanding thing was comments from the EAC upon referral, and we just got those this afternoon. So we just have a couple minor things to update on the site plans in response to the village engineer's comments and some of the EAC input. So we will be submitting that when they're ready. We missed the November submission deadline, so they'll be in for the planning board December meeting, but we will also be appearing before the planning board again later this month. And this is what we hope would be our last extension of time. And as Jaime mentioned, in theory, I think the planning board could take final action next month or the month after.
Is there anybody else from you guys that would like to make any comments?
I'm not sure if Paul's on, but if he is, I don't even, unless you have any comments from us, I think that's basically the sum and substance of it.
All right, I'd like to ask each of our board members if they have any comments. Kyle, do you have any comment on this? No.
Only that it seems in line with the previous granting of the extension. They've been pursuing what seems in order everything that they're supposed to do, and they're kind of waiting on the village process to see it through, so.
George, do you have any comments?
No, they would have been the same as yours, so
Mhm.
I agree with you.
And I absolutely agree with Kyle where we're at. Mark, do you have anything to say other than what's been said?
No, hopefully this is the last one.
Great. Okay. Then if there are, I guess it's time to ask for a motion to open the public hearing.
So moved.
Second, Kyle.
Okay, so motion by Mark, seconded by Kyle. Timmy, did you call this, so you ask if this is unanimous? Anybody not want to do a public hearing? Great, then consider the public meeting open and let's see what the public has to tell us.
So the first is I have a letter here from, or I have an email here from Alexandra Farrell. She sent this email in today at 5:19 p.m. The email says, "Hello, Mr. Martinez. My name is Alexandra Farrell, and I live at 78 Walden Road in Ossining. I'm writing today regarding ZBA's 2119-81-89 South Highland Avenue, Birch Brook Manor Inc. Owner in an MF1 zone district. I understand the applicant is before the zoning board tonight, November 9th, 2021, requesting a fourth extension of variances previously granted for this property. I'm asking that the board consider this application carefully before approving a fourth extension. There are new members of the board who were not present during the initial presentations by this applicant and should be given the opportunity to review the project in detail before another extension is approved. In addition, there have been changes to the regulations surrounding this current property, including a wetlands ordinance that should be taken into consideration before extending this approval a fourth time. I ask that the extension not be granted this evening in order to provide the board time to consider this application and all aspects of the plan to develop the property. Thank you, Alexandra Farrell." And with that, we don't have any hands raised. So that's the only comment we have.
All right, in that case, can we have a motion to close the public hearing?
Motion to close?
Second, Mark Birchny.
Cool. So we have a motion and a second by George and Mark. Anybody not want to close the public hearing? Then by unanimous consent, we've closed the public hearing.
Can we just be clear on how long they're going to be given for an extension? Because I believe that the village recently adopted a change to the code. It's no longer that that 6-month extensions are allowed, and I believe that the code now allows for 1-year extensions.
Right.
A cap on of 2 years on that. So what exactly are you requesting, Mr. Glad? Are you requesting 6 months? Are you requesting more than that?
Yeah, we had just requested in our correspondence a fourth 6-month extension.
Okay.
I hope we don't need all that time, like I said, but just in case, that's what we were asking for.
All right. I believe you'd only be able to, if you do need more than that, you would only be able to get 1 additional extension after that.
Okay.
I have a question. Since we have to wait for the results of the planning board and the new information that's come in, I think it would be appropriate to ask for a motion to adjourn this to next month to review all the new information that's come in. How does it?
So I want to ask a little bit about that. So the planning board has to deal with the wetlands permit. They have to do the wetlands review. As of right now, the seeker process has been completed for this project. We do anticipate that there's going to be an amended negative declaration on this project that would sort of show the enhanced stuff as it pertains to the wetlands mitigation plan. So there's going to be new requirements that weren't required before, sort of enhancing the environmental mitigation to the project. But the planning board can't do anything until the variance is done.
Oh,
So in this instance, the ZBA would have to act first, not the other way around.
I think 2 months.
okay.
So I mean, you can still not vote today. That's obviously an option, but
So if we did that today, we would give them the variance with the understanding that based on the approval from the planning board, yes?
So the variance would be, yeah, they still need to get final subdivision approval. They still need to get a wetlands permit from the planning board. The planning board can't get that without the variance. So the variance only allows them essentially to apply for the approval effectively. So it doesn't, not even apply, I mean, they can apply for the approval, but it's just part of the approval process. I don't think the variance should be conditioned on the wetlands permit.
Okay.
Like they're,
So
I don't know, Amanda, maybe weigh in on this.
Well, I also just want to remind the board that this variance that was granted in relation to the existing lot for the existing apartments, which is, so hold on, I'm just pulling up the prior resolution. It was an area variance related to the required minimum lot area per dwelling unit, because that existing lot has a number of apartments already existing on it. And so in order to subdivide, they needed to get that area variance to create a smaller lot than would otherwise be required. So consider the nature of that area variance here. That is what you're extending in relation to, the wetlands issue that is before the planning board. And I don't necessarily know how, wrapped up you need to get at this moment in what the planning board is considering. They have plenty of, they're fully engaged in the wetlands analysis. They have the EAC comments. This variance is its own beast, so to speak. And that's just my 2 cents here. I know that's not really addressing what you just said, Jaime, but that's my.
Yeah, I think we're sort of, yeah, we're getting to the same thing here.
we need to go through the steps then before we take a vote on this?
It's just an extension. You don't need to go through. You're not reapproving anything.
Then I'd like to call for a motion to approve the variance at this time.
Approve the extension for their requested 6 months.
Yes.
Okay.
So moved. Kyle Beckley.
Second, more questioning.
So we have a motion and a second. I'd like to have a roll call vote on this.
I think we had, who was the original first and who was the second?
It was
Kyle and Mark.
Violet Mark.
Second. Okay, and then roll call is Bob Dariah,
Aye.
Kyle Beckley,
Aye.
George Bailing,
Aye.
and Mark Gorechny.
Aye.
Okay, so the motion passes 4-0.
Right.
Okay.
So now I guess we can move on to, thank you, by the way, folks.
Yes, thank you very much.
Have a good night, Alec.
You as well. Thank you.
Where are we? We're now on to ZBA 16/2021-17 Pleasantville. And I believe that's adjourned because they didn't get their noticing done in a timely way. Is that right, Jaime?
Right.
Okay, good. Well, we can move on to ZBA 19/2021-5 Ogden. This is an area variance for a minimum distance for construction from the Old Croton Aqueduct under the zoning code 270-37A. Basically, they built a gazebo and it's 1 foot over the line for the variance that they got. Jaime, you want to go over what's happening there with that?
Yeah, so the applicant essentially went to the, to the building department to get a building permit to build a gazebo, which is allowed. They essentially, at the time they had a survey that did not show the location of the OCA. So they built the permit, got the permit. When they went to close it out, they needed to get an as-built survey. The as-built survey showed that the new gazebo was 1 foot into the OCA 25-foot setback that they're not allowed to build in. They were unaware because it wasn't on the survey that they had prior to that. And so the building department wasn't aware. They, simply stated that they would not have built it there. They would have moved it over the foot had they known that they were not allowed to build there. So they're here today to get a variance for the 1 foot. The gazebo's already been built and we have pictures of it. The owners are here.
Good.
The owners are Jeffrey and Rennie Kriz. And that's them smiling in the corner.
I see them. Would you
Al-
like to-
Also, just to add, originally, they owned two lots. One is 5 Ogden, and one was known as 9 Ogden. And then when they wanted to put up the gazebo, part of where they wanted to place it, they needed to merge the lots. So originally, when they had the survey, it wasn't combined as one lot. So they went through the process of merging the lots, recording this with the county for for record of changing the lot line to merge them at the time. And I believe that's when the survey was created, which now showed the aqueduct. So that actually occurred. That actually only showed up because they had to get a survey after they merged the lot.
Thanks. Would the applicants like to make any comments at this time?
Henry, go ahead.
Yeah, I thought you explained everything quite well and the process, and we tried very hard to follow all of the rules and regulations, and we did not know ourselves that there was a 25-foot setback from the old Croton aqueduct. And had we known, it would have been so easy for us just to move it prior to the gazebo being built. But that's where we are, and so we're trying to do the right thing.
All right. Do you have any other comments at this time?
No, I hope we've made everything as clear as possible. And
Thank you. Hearing none, I'd like to ask for any comments from the members of our board. Kyle, do you have any comment on this? Kyle?
Sorry, I couldn't get my button to pop up.
All right, brother.
I did, but I forgot it, so not right now.
All right, George?
No.
Pretty straightforward. Yeah, I agree. I think this is very straightforward, and this was something that was accidental in nature, and they would have done something different had they known. They seem like nice people, but apparently they're not very good psychics, and we can forgive them. So that's okay. Mark?
I agree.
Oh, I know what my question was. This variance is only being permitted for the gazebo going over a foot and not to any other future things they put on the property, regardless of whether or not they need a permit, right?
Mm-hmm.
Great.
Yeah,
Right.
it's worth noting that the house itself is already encroaching on the 25-foot setback. So the gazebo is not as close as the house is.
Okay. If the board has no other comments, then I need a motion to open the public hearing.
So moved.
Second.
Yeah.
So we have Mark and George second. If there are no objections, I'd like to pass this with unanimous consent. Hearing none, then the public hearing is now open.
Well, we had somebody who raised their hand and then they lowered it.
Oh,
So,
so seeing no other raised hands from the public, we need a motion to close the public hearing.
We don't have any written comments, I'm assuming?
no,
So moved, Kyle Beckley.
Thanks, Kyle.
Second, George.
So motion by Kyle, seconded by George. We need a roll call vote for this, Amanda.
It's just to close the public hearing, so you
Oh,
can,
I'm sorry. Close. Can we do this by unanimous consent?
yes.
Great. Then the public hearing is closed. Do we have to go through the steps now, I believe, right?
You should, yes.
I think so. Okay.
All right, so for an area variance, the first factor is whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the area variance.
Mark?
No, the gazebo's already there. It seems like a perfectly nice gazebo and it's only a foot, so.
I agree.
Yeah.
George?
I agree. I looked at the plans in the area.
And Kyle as well. All right, what's next?
The next is whether the benefit sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance.
Kyle?
No, because it's already built.
Mark?
I agree.
I agree too. Next,
Okay. The requested area variance is substantial.
I'm gonna say no, it's a foot.
Yeah, I agree.
Mark
I
I'm gonna
agree.
say no for all.
and
I
Kyle?
agree.
Yes.
Same.
And, do you feel that there will be any impacts as a result?
No.
That goes to the substantial factor.
Yeah.
It's not as close as the house, and there have been no impacts with the house there noted, so I would say no for that reason.
Mark?
Agreed. Yeah.
Yeah, we do too. So
Okay. And the next factor is whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district.
Kyle?
No, for the same reason that the house is already closer than that, and it's only 1 foot.
George?
I agree with you.
I agree also. Mark?
Same. It's already there and it's only a foot. So
Okay. And lastly, the alleged difficulty was self-created.
Well, yeah, but I don't think it matters.
I don't think it matters either, but the answer for me would be yes, because we can't preclude somebody's survey not being done correctly. So I think we should note that.
Mark?
Yeah, I think that's an important piece of the self-created here. Even though they did intend to build a gazebo, they did not intend to build it within the setback.
Correct. Mark, do you have a comment?
agreed. Yeah.
Right. So I think
Okay.
that's it, right?
Yep.
There are no other people who wanted to comment, and I'd like a roll call vote I'd like a motion to approve the variance for 1 foot.
You're not making the motion.
No,
Bob.
I'm calling for one.
Okay.
So moved.
Okay. Mark?
Second, George.
So made by Mark, seconded by George. Can we do a roll call vote, please?
Yes, Bob Dario,
Aye.
Kyle Beckley,
Aye.
George Bailing,
Aye.
and Mark Gorechny.
Aye.
So
Motion passes 4-0.
thank you, folks. Enjoy your gazebo. It looks lovely.
Thank you very much. You're extremely kind. We appreciate your time.
You need to throw a gazebo warming party. Mostly because
Yeah, it doesn't get
I just
very
want
warm
to
in
say that.
January.
gazebo warming. Okay, so we did that, and the next one is ZBA 20-21 70 Croton Avenue. This is area variance in order to add 4 apartments to the ground level of an existing parking building. Jaime, do you want to update us on where this project is?
Yeah, so we met with the applicant yesterday. There is still some internal discussion going on about the extent of the variances that would be required. We've requested some additional information from them. So since we're still kind of in the middle of the internal review aspects of this, and we just want to make sure we don't waste their time and waste your time, we have administratively adjourned it to next month.
Okay, so we can move on. ZBA 22-2021 16 Campwoods. It's a request for interpretation pursuant to zoning rule 270-48A1. And the issue before the board is,
Bob, you don't have to read that part.
I don't. Well, then I won't.
Okay.
Okay, so Jaime or Amanda, would you like to run us through it, please?
I'll let them handle this.
Okay. This is a request for an interpretation, as you noted, pursuant to 270-48A1, which is basically our section in the code that allows for interpretations. The applicant is asking you to interpret a particular section, 270-38B, which is the section in the code related to continuance of non-conforming uses, which would apply to allow for pre-existing non-conforming uses that had been in effect prior to the establishment of the village's zoning laws, which I believe were adopted in 1931. So in this case, and Joe, please feel free to correct me if I get any facts wrong. The property is located in the S75 district. Let me just make sure that's right.
Correct.
S75, okay. And so that's a single family residential zone. The applicants have a commercial use on the property, and that's been operating for a number of years, which also includes a multifamily home. They recently received an appearance ticket from the building department that asserted that their commercial use was an illegal non-conforming use, which needed to be remedied. And they are now before your board seeking an interpretation of the code section that I cited, that continuance of legally pre-existing non-conforming uses, to seek an interpretation that the building department's determination was incorrect. And in fact, they have a legal pre-existing non-conforming use. So that's essentially what we have.
Okay. So essentially, since the zoning code was instituted in 1931, the applicant needs to show that they were a pre-existing non-conforming use in that specific place prior to 1931. And the onus is on the applicant to prove their case. So if they're here and would like to speak, now would be a good time.
Yes, we would like to hear from the applicant.
Yes.
So we have Darius.
No,
No, not Darius.
wrong application.
Wrong application. Okay, I'm sorry. We have Sam Taturka. And we have Lauren Apollonio. Sorry.
Good afternoon, or excuse me, good evening.
Okay.
Have the Apollonios joined as well?
Yep.
Okay.
All right, hi.
Hi. Okay. So, yeah, shall I start?
Please.
Okay. So yeah, I think Amanda characterized the application that we're seeking correctly. And since we only have 5 minutes, I will keep my remarks fairly short, and because I want to leave some time for the Apollonios to speak as well. I just want to note that this is a fairly unique application. The business that's been operating on this property has been operating for almost 50 years, and it's been operating there, with the implicit permission of the village. The first time that the Apollonios received a notice of violation was in 2015. And prior to that time, they had never received any complaints about the operation of a construction yard on their property. None of the surrounding businesses had ever complained. And they had never received word from the village that they were, to our knowledge, that they were in violation of the zoning code. And when this issue first arose with the village in 2015, my clients in the village tried to work out a solution that did not involve having to appear before the ZBA. The village, to our knowledge, the village told my clients that they intended to rezone the property to bring it into compliance. For whatever reason, that fell through. If we then began negotiations with village staff, with the planning department and the building department about potentially rezoning this property to the NC2 zone, which presumably would have brought the property into compliance with the zoning. And that rezoning was conditioned on the neighbors on the neighbors at 20 Campwoods Roads also agreeing to rezone their property to the NC2 zone. And unfortunately, the neighbors were not willing to go along with this rezoning. So this is really this I guess negotiation or saga with the village has been going on for 6 years. And, we've been trying to work with the village to find a solution, but nothing has seemed to come to fruition to avoid coming to the ZBA. So we're here today. And I just want to emphasize that, the construction yard and the business that's being run on this property is really my client's livelihood. It's been a family-run business on the property for nearly 40 years. And, prior to 2015, they really had no indication that what they were doing was not in conformance with the zoning. And it would just be a real shame if for some reason the village decided to just shut this business down and really devastate my client's business. And I just want to allow the Apollonios to speak as well. So.
You can take longer than 5 minutes. It's fine.
Okay.
Thank you.
Take it.
I'm John Bautista Apollonio. My father bought the property in '78 when he started his business, but the property prior to that was also the same usage. That's the reason why he bought the property. He wanted to build life for himself here, in construction. And I followed in his footsteps, and I'm still trying to do the same thing. And it is my livelihood, it's what I do.
I think the biggest thing is that we understand what the village is trying to do as far as like making more into neighborhoods, and it's an eyesore. So we are willing to work with you. Maybe clean up outside, some more fencing, put some trees, so it fits the village's new vision for Ossining. It's not that we just want to stay exactly the way it is. We're willing to work with you so that it can be mutually agreeable for the village of Ossining, and then also for the Apollonios, because like my husband said, this is our livelihood. It's how we pay. I mean, the company, it's Carmelo Apollonio. My son's Carmelo Apollonio. We're hoping for it to be third generation. We're invested, and we're invested in the community. And, we're willing to make it work, or to do whatever you guys need for us to even if it's maybe we have to get rid of some of the equipment, maybe we have to knock down one of the buildings in the back. But we're willing to work with you. I think that's what I want to stress.
Do you have any other comments at this time? If not, then I would like to ask Joe to make any comments he has on this at this time.
Well, first I would say to correct some of the information that is being brought to the board. Violations of this nature of operating a business at this site with commercial vehicles and machinery, which I'm looking straight into my computer at this point. Violations have been issued for this going back as far as 2005. So it's not something that's been brought to the Apollonios recently within the last 5 years. It's actually something that that the village has written violations for this going on to almost 20 years. There's been at certain times in the past where there was discussions about trying to work with correcting some of the things on the site. And I guess there's never been any viable way on how to deal with this. I mean, the district is a single family zone district. There's already a 4-family home on this property. It also has a large construction business in the rear yard. There's large trucks there. There's numerous numbers of buildings that are behind there. They've been constructed over the years. We don't have any records of how these buildings were constructed. There are no permits for any of them. The other thing I would say also, I guess a question to the Apollonios that I would have is, you actually live at this address.
Yes.
You live here because in our system, it says that you don't live at this site, that you're not a resident in this area, that you run your business here, but you don't actually live there.
You have the address. What address do you have? 1261 Underhill Avenue?
We have it recorded that it's taxed to an address in Yorktown Heights.
Yeah, so that house was actually sold, and we were living in Ossining.
So, I mean, like I said, we've gone back to records for tax assessments. The tax assessment roll goes back as far as the 1950s. There's a assessor's record that says in 1950 it was a single family home. And somewhere over the years, this became what it is today, but there was no record of a commercial, doesn't mention anything of a commercial business there back in the 1950s, which obviously is prior to when the Apollonios purchased it. So they may have purchased the property with some sort of commercial use there, but the village does not have any record of such. And there is no record, like I said, of the number of structures that are in the rear yard. There was originally on the residential, on the card that was back in the 50s, there may have been 2 or 3 garages in the back, but not the number that are there presently. So that's why these violations were issued, because it's been an ongoing nonconformity. And we've determined that there has never been there is no record of any variances granted for the use there. And that we don't, based on the regulation of, if you have a pre-existing non-conforming use and it goes back to the prior to the zoning code, we don't see that there's any records that give evidence that this property is being used in the manner that it is right now prior to 1931.
Okay.
May I respond to some of that?
So before you do, I just want to mention that you submitted a pretty lengthy packet with a lot of materials in it. I would really, urge you to make sure that the board is aware of all the materials in your packet. So you can, if you would like to, I can share whatever's in that packet here on the screen and go to whatever page you want. So if you'd like to do that, just let me know.
Sure. Yeah. That would be great. I was under the impression we only had 5 minutes. So
Oh, no,
I tried
no.
to keep it short. Okay.
No, you don't.
So, just a couple things. We have records, and we submitted along with our application a memo that was generated by a company. This is the memo, Historical Perspectives Incorporated. And according to this memo, which looked at various historical documents, including newspaper records, Sanborn maps, fire insurance maps, they scanned several historical documents going back almost a century. And I think one interesting thing to note is that according to some of the Sanborn maps, going back to 1924, I believe, there is records of many of the structures that are on the property now existing back in 1924. I think, this is the paragraph you're looking at right now that says that. It says there's 1 to 2, as of 1924, there's 1 to 2 story frame outbuildings at the rear of the lot, and the largest outbuilding appears to contain 4 sections and had a tile roof. And beginning in 1924, one of the larger outbuildings and one of the smaller structures at the rear of the lot was labeled with the letter A for auto house, which we believe is an abbreviation for a garage, which that housed and potentially did work on vehicles at that time. And I think that we submit that this is evidence that there was the property was being used for commercial purposes going back all the way back to 1924. And in addition to that, we also submitted a journal news article from, I believe, the year 1995. That's a little further down in the packet. Thank you for scrolling. Apologize.
That's okay. Yeah.
So this is, I believe, the article. If you scroll to the bottom of it, Yeah, a little bit up. Yeah, so I think if you see here, the third paragraph from the bottom, the previous village attorney, Thomas Barnes, indicated that in this article, he's speaking about 16 Camp Woods Roads. And the owner of the property at that time was Carmelo Apollonio, which is Mr. Apollonio's father. And as you said, as Mr. Apollonio previously said, he bought the property in 1978 and began operating a construction yard there, which John took over. I don't know which year John began running the business, but John has been continuing that business ever since his father passed away. But in this article, the previous village attorney, Thomas Barnes, he says that the business has a right to be there because it has been there for more than 20 years. So I think in this article, the prior village attorney is recognizing that, yeah, this is a pre-existing legal non-conforming use. And again, I want to stress that, no, we don't have, a smoking gun document saying that there was a construction yard on this property, prior to the village's enactment of its zoning legislation in 1931. But I think if you look at the totality of the evidence, I mean, the facts that are provided in the historical perspective memo, this Journal News article, the fact that the village apparently, didn't begin enforcing zoning violations for almost 40 years. After my client's father purchased the property, it's I do think there's a significant amount of evidence on which you can rely to find that this is a valid pre-existing legal non-conforming use. And yeah, so I think I'm just trying. Let me see if there's anything else.
Can I ask a question?
Sure, go ahead.
If at any point since they've owned the property, have the owners come to this board asking for a use variance for the property? Other than this, which is an interpretation, not a variance request, have you utilized your ability to ask for a variance from the zoning board at any time prior to tonight?
So we haven't come before your board asking for a use variance. And I think the reason for that is that let me just say one thing. I know Joe, the building inspector, recently just said that there were violations issued against this property in 2005. I haven't seen any of those tickets issued against my clients. I don't know if my clients are aware of them. So that's just something we've never seen.
Okay.
So excuse me.
That wasn't my question, though. Have you?
No, the reason I say that is because we didn't become aware of these issues until 2015, and at that time we had received my clients received assurances from the village that the village was going to, on its own motion, attempt to rezone this property to a more appropriate zone.
And I apologize because I've only been here a year and 8 months or so, but when did you receive those assurances that it was going to? I know we had conversations asking them during the time that I've been here to see when were those assurances provided that it was going to be.
So I think my clients can speak more to that than me. That's before my time with them. So if Joe and Lauren, would you mind chiming in on that?
So the first violation that I know about was in 15, and I'm not sure if it was 16 or 17.
16, because I had to scan a copy of my father-in-law's death certificate, and he passed away in October of 2016. And I remember having to scan a copy of his death certificate, and then we had retained also Zarin Steinmetz, and David was actually on that case. And David requested it, and it was pretty much like, okay, there was some kind of list. It was a different administration, And there was some kind of list, I guess they were going through and they were looking into rezoning.
They wanted to change the whole street to
Right, 'cause-
NC2 zoning, including around the corner, past Independent Hose and the pool company
Where Aqua
and the
Pro is.
Gospel
Yeah,
Assembly.
yeah.
All that was supposed to change over to NC2 zoning during that time. That's why they dropped the violation on us. And now it came back.
Can I just make a response to that, by the way?
I would really love to get an answer to the question I originally posed.
Yeah.
Have you at any time since these cases come up, have you put in for a use variance in order to get a variance to use this property for the use that you are putting it to, rather than the residential use that it's zoned for? That's a pretty much a yes or no question.
No, and I thought I answered this at the beginning. No, we haven't, and I think,
Thank you. Okay, good.
yeah,
I'm done.
and I just, the reasons we haven't is because we've been involved in negotiations with various village staff.
And you know that is an option, right? That you have.
Yes, we're aware. Yeah.
Well, can I just to make one statement? One of the things, if there was a discussion about turning this into an NC zone district, to remind you that this type of use is not even allowed in an NC district anyway. So that either way, if they were continuing this use and it was even turned into an NC district, you would still have to get site plan approval. You would need from the planning board, there would be variances that would be needed to be sought as well, because that district doesn't allow you to have a construction yard in NC district. The other thing that I want to also bring is to mention is what was said here by the applicants here is that they were not aware up until 2015 of this issue, but yet we have an article here where it's Carmelo Apollonio is stating back in the 1990s that it says here that the business set is being drawn more attention because of economic recession. Up until a couple of years ago, the only thing that was coming home was small trucks. So back in the 90s, this was being used with a number of vehicles that were there. Trustees were frustrated about the inability to control a contracting business on Camp Woods Road. So, for a response to be made in a paper here that Carmelo Apollonio is made aware that there is some issues with the village with the way this property is being used, means that the Apollonio family was well aware, even going back into the 1990s, that this was an issue. So, I find it a little bit difficult to understand that only in 2015 is the first time they're being made aware of this, when the article that they're bringing in evidence basically stating that he was aware it was an issue.
Well, I think that the underlying point we're trying to make is that prior to that time, we weren't aware that the village was intending on enforcing its zoning regulations and shutting this business down. I think that's really the ultimate point.
Well, I think that, to be fair, just because there were no violations arguably issued before 2005, the village hasn't waived its ability to enforce its zoning.
No, I'm not arguing that either. I'm just stating, I'm just stating that underlying rationale.
Yeah, I mean, I think that there's a lot to take here from the chair's comments about whether you've applied for a use variance and the comments that you've made that might be useful to you in a use variance application down the road. If you could try to steer your commentary towards the facts of this case and whether or not there is an existing non-conforming use, rather than sort of justification you may use down the road on a use variance application.
I think Kyle had his hand raised.
Yes, so I read through the documents. We had a legal meeting about it to make sure we understood the parameters. And I've just been making a bunch of notes, and there's a couple really important things I think we need to discuss, which Bob, the acting chair, addressed, which the most important being, this is not a variance application, this is an interpretation. So in this interpretation, we have to look at the code as it is written, without emotion, without preference for the feelings of one party or the other, right? We have to look at whether we believe the code as it's written was interpreted correctly by Joe, correct?
I agree with that, sure.
And so for a point of clarification, could we pull up Amanda or Jaime, the code that's referenced?
Yes.
If you want to pull that up, Amanda.
Yep, I'm just going to the code. All right. So here. All right. So here's the relevant section, particularly B1. This is what we're talking about.
Great. So in subsection 2070-38B1, in past cases that have been ruled, it's my understanding that the precedent has been set that in this sentence or in this regulation, when you read, or prior to the establishment of any zoning regulation in the village of Ossining, for which this zone was a two-family zone in 1931 until 1960, when it went to a single-family home, it was in the 1960s.
Yes.
And then when it was a single family, at the very least, you would have to prove continuous commercial use in the 70s when your father bought the home for us to say that Joe interpreted this incorrectly. Without that evidence, I don't see us being able to make any other decision but agreeing with the determination. We can't make a determination based on anything other than evidence.
Yeah. George, what do
Yeah,
you think? You
I
agree?
agree.
Mark, how do you feel about this?
No, I agree. And I think it actually probably even goes back further than that. I mean, it's before the actual code itself. So, I mean, even though there's some, I don't think there's any indication whatsoever about the fact that the property was used, for what it is now.
There's no record.
No
So
record.
at this point, if none of the other members of the board have any other comments, then I would like a motion for opening a public hearing.
Bob, was Mark finished there? I think that he was.
Oh, I'm sorry. Did I cut you off, Mark?
No, it's fine.
Okay.
Yeah.
Sorry.
So can we get a motion for a public hearing?
Motion for public hearing?
George?
Second, Mark Rechny.
Mark? Okay, so it's George and Mark. I would like to do this by unanimous consent, hearing no objections. Public hearing is now open. Jaime, do we have people wishing to speak from the public or any email or other correspondence?
Where are you, hon?
No, we don't have any email correspondence. We don't have any hands raised. I did get a phone call the other day, somebody who was just curious about what was going on. The comment that I received, which is from a sort of an unnamed neighbor, was that whatever does happen on this property, they just want to make sure that it doesn't expand in use.
Okay.
They noted that they didn't really know what was going on over there. They had no real complaints, only that whatever, commercial use is going on, they do not want to see any expansion of it. That was really their only comment.
So if there are no other correspondence and no other people waiting to speak, then I'd like to entertain a motion to close the public hearing.
So
Motion
moved.
closed.
George, second?
Kyle, second.
Okay, so motion by George, second by Kyle. I'd like to do this by unanimous affirmation. If anybody has no other complaints, then I declare this public hearing closed. And at this time, I'm looking for a motion to uphold our building department's ruling.
So moved, Kyle.
Mark Rechny, second.
Okay, so Kyle and second by Mark. I think we need a roll call vote for this, Amanda.
Yeah, and I just want to be clear, you're upholding his determination based on his determination of the code section at issue, right? 270-38B1.
Yes, basically, we're upholding the fact that there was no evidence that there was a non-conforming use prior to the code in, was it 1931? And therefore, he is correct.
Okay. So the roll call is Bob Durayo,
Aye.
Kyle Beckley,
Aye.
George Bailing,
Aye.
and Mark Gorechny.
Aye.
Unanimous. Thank you for coming in.
Thank you.
So the next thing on the agenda is ZBA 23-2021, 34 State Street, which is Hudson Step. Now, at this time, I am going to recuse myself because this project abuts my property. And also, one of the people involved in it is a 20-year friend, and he built my house. So to avoid the appearance of impropriety, I am going to step away and recuse myself for this case and turn the meeting over to Kyle.
No, it's actually to Mark.
Well, actually to Mark, I apologize.
All right.
Who knew? Thanks for the
Okay,
trust.
so I'm going now.
And I just want to note for the applicant's benefit, since there are now only 3 members participating, the applicant would need a unanimous vote of all 3 participating members in order to reverse the building inspector's determination here. Just want to put that out there. And so now, Mark, you are at the helm.
Thank you. So this is an appeal from a decision of the building inspector to revoke a building permit pursuant to Village Law Section 7-712A. And the grounds for the revocation of the permit was Village Code Section 162-28I. I'm going to ask either Jaime or Amanda if they could describe the application to the board.
I'm going to defer to Amanda on this one as well.
Sure. So this is a situation where, and Joe can correct me if I get anything, if I misstate anything, but the Ossining Land LLC, the owner of 34 State Street, is seeking an appeal of the building inspector's determination to revoke their building permit pursuant to the section you just cited. This is a straight appeal under the village law, that section 7-712A. It's not an interpretation, so you're not being asked to make any specific determination about a section of the code language. It's just an appeal, and so they are asking you to make a determination as to whether the building inspector's decision to revoke that permit was proper or improper. Their claim is that it was improper for the evidence that I'm sure that you'll hear from them tonight. The building inspector made that determination based on certain evidence that the village law requires that he have provided to you. There are, I believe, 3 documents that that the building department provided, and so I think that we have those on the agenda, or if not, I can pull them up. Basically, it was the letter from the building inspector to the applicant informing them that their permit had been revoked, the building permit application, as well as the building permit itself. Those are part of your record for review, and then you also can hear from the applicant to determine, oh, thank you, Jaime, to determine what the proper determination should be.
Is there anybody here to speak on behalf of the applicant?
There is, just before we bring them in, I wanted to make sure that you've had an opportunity to ask Joe any questions, since you're reviewing an appeal of a decision he made. Did you want to ask him any questions first?
Actually, Joe, is there a copy of the? I believe that there was a previous permit before this one. Is there a copy? Was there a copy of that included in the application itself or otherwise? Is that available?
The permit that was issued before the building permit was a demolition permit. That was to, obviously, to remove the commercial building that was there previously. I don't know if that's actually in the package here.
That's
But
fine.
it was a demolition permit that was issued, and that was just to remove the commercial building that previously stood on this property.
Unfortunately, that packet of information was too large to include as a link on the agenda, but it was sent separately.
If it's something that you guys need to take time to look at, you know, if you haven't had time to look at it for tonight, then you can always do that.
Yeah, we can go through the packet that was sent and break it up into smaller pieces so that it is something we can upload. So that's something that can be done. We can also invite the applicant in if they have copies of those. They can share them as well. So if you're ready, I'll bring over, we have multiple individuals here for this. We have Darius. I'm not even going to attempt. I'm afraid I will mess up his last name. From Harris. Okay. And we have Jonathan Close, representing the ownership.
Okay.
Good evening, Mr. Chair. Darius Shafazada from the law firm of Harris Beach for the applicant. We also have Alfonso Kimchi on the line. Jaime, is there a chance you can get him in too?
Yes.
Mr. Chair, I'm here with Jonathan Cluse and Alfonso Kimchi with the applicant Austin LLC, Austin Land LLC, excuse me. Thank you for your time tonight. And we are appealing from a decision of the building inspector which revoked a permit. Now the revocation, I'm not sure if it's available for you to look at. It was in our packet. We've submitted a detailed letter dated October 15th, 2021 with details of why we believe the permit was improperly revoked by the building inspector. I want to start with the building permit itself. The building permit was issued, and Mr. Martinez, do we have that building permit available on the packet to put on the screen?
Unfortunately, no, I apologize. We do not have that up here.
I might be able to pull it up if that's okay.
Mm-hmm.
That's exhibit 4 of our letter of October 15th.
All right. The actual building permit, correct?
Correct.
All right.
I thought that was in the 3 items.
That's what I'm grabbing. Yep. Yep. All right, here you go.
Okay, so here's the building permit. It's issued, if you'll see.
Sorry.
That's okay, on January 19th, 2021 on the top left.
Where did it go?
I see it up there. I don't know if the board can see it.
All right. Yep.
And so it's issued on January 19th, 21 for earthwork and foundation for 3 apartment buildings amended on 1/19/21. And it goes through what is going to be built. So what happened then is, in addition to the building permit being issued, there are extensive plans of the work that was going to be submitted. Those were also submitted to the zoning board here. They are extensive and very large, and we don't need to pull them up, but they were design plans, stamped, engineered, architect's plans for the construction of these 3 buildings. Permit was issued, and now work began. What happened though, in July 19th, 2021, the building, the date was, exhibit number. Get the right exhibit here for 1 second. Okay, here it is. The next exhibit, which is exhibit 5, which was the building inspector's determination. On 9/15/2021, the building inspector revoked the permit, determining it was invalid and has been closed. That's Exhibit 5 to our October 15, 2021 letter. And the reason why, and we'll show you in a moment, the actual document was, according to the building inspector, that the proposed scope of work has not commenced within the time limit as indicated in the Village of Ossining Code. Now, the Village of Ossining Code is referring to section 162-28I, that's up on the screen now, which requires the authorized work is commenced within 6 months following the date of issuance. So we just saw the building permit January 19th, 2021. That means that the work that's authorized in the permit needs to begin by July 19th, 2021. We believe the overwhelming evidence provides that it did begin prior to that date. And I'm going to walk the board through that which is set forth in my letter and set forth in all the exhibits. I would first refer to Exhibit 7 of our submission. It's a series of emails, members of the zoning board, starting on July 19th, 2021.
Darius, do you have the ability to share? Jaime, can we give him the ability to share his screen, because I only have those few exhibits?
He has it.
Okay.
I have to find, hold on, let me try to pull it up.
Okay, that would be easier.
It would take a minute. I'm on my iPad. Wish I would have known. I would have done it.
Can you go back to the original link that was forwarded to us?
I'm trying to do that. I think that came from my colleague. I'm looking for it right now. It's going to be tough for me to find on my email. These were all submitted in hard copy. I don't know, does the board have the hard copies too or no?
No. I apologize. Can you tell me who from your office emailed it? Perhaps I can pull it.
Would have been Matt Dudley, Dudley. Would have been on that date of the letter. October 15th.
So Matt sent it to Jamie. Jamie, are you able to forward that email to me?
I can try. Give me a moment.
I just sent it to you. I think that's what we're looking for.
Wonders of Zoom, right?
Yeah.
Well, this is, this is a lot faster than if we weren't sitting in front of a bunch of get this all here. So
Yeah, that has the share file link in the.
all right, I just got it. Yeah, great. All right.
Thank you, Amanda. Thank you, Jaime.
Thankfully, I have a super fast gigabit internet app connection here. So just give me a moment and I'll be able to. 307 megabits, so megabytes. So, no, look at that. It's 25%, 59,
You got a good internet connection.
97%. That's just, yeah, that was great. All right, so we're opening this.
I'm an old paper guy here. You see this?
Okay.
Okay, great.
Yeah.
So I'm at exhibit 7 to my affidavit.
Okay.
Oh, excuse me, my letter. Pardon me.
All right. Do we know what page?
I don't. If you go, they're all labeled, all the exhibits, so it's probably about half. I mean,
Okay.
it'll be after the plans. Yep, plans is 6, so it's the next exhibit. Those are the detailed plans I was referring to earlier.
All right, we're
More than half.
way more than half. Yeah.
Yeah, sorry for the,
It's no, I think my computer is just having trouble keeping up with the 307 megabyte set of plans. There we go. All right, we're getting close. All right.
okay, there you go. That's the letter right there, the email. So there's email correspondence on July 19th, 2021, which is our exhibit 7, that goes back and forth from village attorney, Mr. Kahan, and Jonathan Cluse from my client. If we can go to the last email on that, it's page 2 of exhibit 7.
Just give me a second.
Sure, thank you.
It's taking its time. Okay, so here is the first email.
There's the letter. Yep. So Mr. Kahan is sending an email to Mr. Cluse. I hope that you are well. I have been advised by the village's building inspector that excavation has started at the site. Can you confirm, and also can you identify the general contractor for the project? Thank you. That's from Mr. Kahan. The response by Mr. Cluse about half an hour later says, I'm well, thank you. Hope that the same with you. Yes, we started excavation at the site, and the general contractor is ASF Construction and Excavation Corp. Now, if you recall, earlier, I read you the permit revocation from the building inspector. And the reason why the permit was revoked is because the proposed scope of work was not commenced yet. And I read earlier also the building permit, which showed that excavation was one of the things that needed to occur. So obviously there was an issue of whether excavation was beginning back then. The building inspector informs the village attorney that their excavation had begun, and that was confirmed by my client. And that was on July 19th, 2020. Now, on exhibit 5, the email to terminate the building and permit we just cited to. So now the question is, what was occurring then? I would note too that there was a violation issued. Exhibit 9 to my submission. The violation was issued and signed off on by the code enforcement officer of the village, Mr. Gregory Gross. It's probably the 4th or 5th violation of Exhibit 9. Here are pictures of the work that was, which we'll go through in a minute, what this exhibit is. But I want to reference the violation and the facts supporting the violation. There's Exhibit 9. Okay, keep going down. So this is violations to my client. Some have to do with the Smith Robinson house, but one specifically number 4, the 4th violation on page 5 of 11. You'll see there, Jaime. There you go. At the above time and place, I observed unsafe hazardous conditions on the property. And I'm paraphrasing there, but the second sentence is key. There are holes caused by excavation work, piles of large boulders and debris from the demolition of a building a few months ago, an unsecured water well. This is a violation issued by the Village of Ossining, saying there are holes on the property caused by excavation work. And the permit was revoked because work allegedly was not being commenced on the property for the development. Now, I want to go now to Exhibit 8. Now, Exhibit 8, I'll set it up for the zoning board of what Exhibit 8 is. Exhibit 8 to my letter are engineering reports, daily reports by our supervising engineer, third-party supervising engineer on the site. First one is dated July 16th, 2021. And it sets forth, the information is reported by James Pupalampu, P-U-P-L-A-M-P-U. That first date, which is July 16th, shows the work that is being done. The contractor started the soil prep. I think one more up, Jaime. The soil prep work at 34 State Street. On-site material was scarified utilizing an excavator, grubbing, silt fence, soil work in progress. And there's photos behind that of the work that is doing and being done by the contractor. The contractor also on the next day of July 17th, the third-party inspector is providing. The contractor started excavation for footing subgrade. Also photos showing that in color for you. This is all before the July 19th, 2021 date. On July 19th, stakeout of survey and excavation for footing subgrade continued, showing the excavator on site with the work that's being performed. All demonstrating work being performed pursuant to the building permit that was issued. This is before the 6-month timeframe. Now, this inspector also submitted an affidavit, which I believe is part of your packet on the site, on the website for this matter. This third-party inspector submitted a signed affidavit under penalty of perjury of the excavation and the work that was being performed on the site. And I'll refer you to the affidavit now that is up on the screen. You can read it. I'll read the major parts of it. They contracted with PE Construction and Consulting in paragraph 2 to provide engineering, consulting, and construction supervision, paragraph 2. He goes through in the next paragraph the work that was being performed and started on July 16th to perform the construction and the foundation work. They began excavating as indicated on July 17th in paragraph 6. That continued all prior to the July 19th date. We also submitted as part of the packet to the zoning board, an affidavit from the individual from JDA Contracting, a Mr. John Dos Anjos, A-N-J-O-S, from JDA Contracting, indicating excavation began in paragraph 5 for footing subgrade of building 1 to be constructed on the property. Paragraph 6, this work commenced prior to July 19th, 2021. Another sworn affidavit. to go back to Exhibit 5 for a moment. If you can, Jaime, thank you. This is a very, very large investment in this village, in excess of $35 million, approximately $35 million in hard costs for the development of this building. We've expended significant sums of money to create these plans, to hire contractors, obtain the building permit, paid fees to the village that were owed, made the village whole with back taxes that were owed. In excess of $1 million was paid to the village. We spent significant sums of money to obtain the building permit through these plans and have begun construction. And out of nowhere, we get this by a termination of our building permit, asking us to submit new plans and pay fees. Again, we think that was improper. We think the evidence is clear. The last presentation showed there's not a smoking gun for the show that previous application was a pre-existing non-conforming use. We have smoking guns, not only one smoking gun, many smoking guns, sworn affidavits from individuals indicating that construction and excavation work has begun within the 6 months. So we ask you to consider our appeal. This is, again, a very, very costly project. Our clients are heavily invested in the village, want to be partners with the village. We want to commence construction immediately and restart again. We want to get this done as soon as possible. We're, again, heavily invested, and we'd ask you to consider our application. Here to answer any questions you may have, and would ask that if you have any, if the building inspector has any comments, that we can respond to them when the issue comes up or at the end of his presentation.
All right, at this point, I'm going to ask the board, members of the board, if they have any questions for either the applicants or otherwise. Kyle.
Thanks, Mark. I'm going to share my screen real quick, if I'm allowed to. Great.
Go ahead.
So here we go. So I was just trying to make a little timeline so that I saw this in front of me of what's going on based on the evidence that we saw. So the permit was granted for construction on 1/19, which means that you have 6 months exactly, so 7/19. And I have some questions regarding why construction started 3 days before the end of the permit. My second question is going to be, I can't make a determination without fully going through the demolition and construction permits individually, because if in the demolition permit, removal of the debris from the demolition is included, then even though the demolition was concluded by order of your contractor, it wasn't completed per the certificate you got from the village. And I can't make that determination today without reading that. The third thing is, I'd like to ask you, when did construction work begin exactly? Since people would have to be hired for that work, there should be an exact record of when that work started and what it entailed. A question I have, just due to my me being on the board for a less amount of time than others, is what milestones are required, if any, in order to maintain your construction permit? So for example, I asked that because I've been driving by that site for 4 years and I've watched everything that's happened there, and any of the below subgrade work that's taken place, I haven't really seen. And so how long do you have to complete that before continuing on with the project, and why is it going at the pace it's going? So those are some questions that I have.
Try to answer some of those. Not really sure what you mean about the demo permit. My understanding is the demo permit was issued and closed out by the village. Demolition occurred pursuant to the permit and was closed out by the village, unless I'm mistaken. That's my understanding with respect to the demo permit. Not an issue at all in this appeal. Jonathan, do you have anything more to add on that?
Yeah, I have to dig it up, but I have an email from Mr. Agostinelli confirming that the demo permit was closed on January 19th. I can forward it to you in a couple minutes. I just need to pull it up.
And the demo permit wouldn't include excavation work, which would be the foundation work. I don't think it would be permitted by the village to excavate pursuant to demo permit.
No, I guess I was asking that question because the debris that was piled up from the demolition, not all of it is gone. So how can the demolition debris be?
Well,
considered-
allow me to answer to that. The demolition permit covers the removal of the building. The contractor stockpiled the debris on the site. But essentially the demolition was completed except for a cleanup. So the piles that you see on site there that you're referring to were the debris from the demolition that were left on the site that were either to be sorted out for use for when the construction was to occur, and certain materials which were not going to remain on the site, such as metal materials and so forth, were to be carted off the site at some point. So what you're seeing there was what was the remains of what was the building, the commercial building that stood there.
If
So
I
our
may-
demo permit is closed out, it's done. Some material can be reused on site to there, and some would be trucked away and disposed of accordingly. But in our thought, not really an issue for whether we began work timely. I think beginning the work timely, your question, why did we begin 3 days or 4 days before the permit was set to expire? Well, we were aware of that date. We were talking to the village about it. There are issues related to when they became owners of the property and had full control, and also getting the contractors ready to do the work and having the contracts done. It's hard to snap your fingers and get it done, but within the 6 months, we were aware of that date, and we did get that started before that date. When did we begin exactly working? I think one of your other questions. I don't know, Mr. Kriz, can you answer that question?
Yeah,
Not demo work.
just to more fully answer the previous question, the piles, the certain of the materials or the piles will be used as part of the aggregate that goes into the concrete for the foundation. So we removed the stuff that's not going to be used, and we kept the stuff that is going to be used going forward. But obviously, we haven't used that yet in concrete. Regarding when did work commence, we started doing site work as early as June, clearing, site maintenance and cleaning just in prep for construction. But specifically site work included in construction like earthwork. Part of the delay, as Darius referenced, is that we couldn't even mobilize contractors because of COVID until the spring. Does that answer your question, or do you need more details?
No, I'm over the demolition permit. Thanks for that clarification. That's just my lack of knowledge in that subject area. But Joe, I have a question. For their permit being terminated, what work did you not see as applicable to the construction permit that, like, what was not done in order for them to keep their permit status?
So just to begin with that, first of all, Mr. John Dos Anjos, who submitted an affidavit, was actually the contractor on the demolition permit. He's not the contractor for the building permit, and he was the person who was always observed on site. When it was discussed with him, what are you doing here with excavation equipment? Which, by the way, he had one piece of excavation equipment. He said, well, I had done the demolition, but I never completed doing any of the cleanup work. So I am stockpiling what they want to keep for the construction when that is to begin. And I'm piling up the debris that will be carted off site to complete what is part of my responsibility, part of the demolition contractor for the demolition permit. So the contractor who we do have on site, or the contractor who is on record, was never observed on site doing any work there at all. And you can see that on the building permit, who is the contractor that is of record. He was not observed as the person we dealt with on site. Also,
we can answer that issue. Please.
That's not a question that I'm not asking a question.
But it's a comment referring to hearsay when an unsworn, everyone's unsworn. We have sworn affidavits that this contractor was doing the excavation work on site.
Darius, I think it's appropriate to let Joe first finish his comments and then you can respond afterwards.
We'll take notes on each one, okay?
Okay.
So again, so the referring to the third-party inspector has to file with the building department since he will be submitting reports to us. He has not filed any credentials or anything to us to put him as part of record as a third-party inspector for this at all. And when we say on the permit about, and you're talking about referencing to this building permit, if you look at the plans, a lot of it is to deal with just the construction of the buildings. So you would be digging for footings, foundations, setting up those footings with rebar. Those would be the reports that we'd be getting from the third-party inspector, because the third-party inspector is really supposed to be on site for the purpose of, since we're not there 24 hours a day while the construction's going on, we rely on a third-party inspector to let us know the day that they're pouring concrete. Is the concrete, has it been sent out for testing to a laboratory for consistency? Is the proper rebar in place there? What are the ground conditions during this pouring? And what are the conditions of the day when the pour is happening? Those reports that he has over there is referencing prep work, meaning they're clearing out some of the debris, the site, putting up some silt fencing and so forth. That's not actually part of what we consider part of the construction on that permit. There's no actual building beginning there at all. No, there's no digging for any footings, for any foundation work. What we're talking about is clearing debris, which is part of what the demolition contractor had left behind that he's sorting out. So our determination is that the actual work with regard to the building plans to do construction has not started at all. There is nothing dug on site to prepare for any type of footings for any construction to be done. If there's a surveyor who came out and flagged out some surveying of the property, that's all preparation work before you begin your building permit process. So, the contention that I have and the building department has is that essentially none of the work with regard to what is on those plans or what is in regard to doing that building permit is actually what has started. We're talking about prep work that usually occurs before you start working on the building.
Can I respond?
Respond.
I can, okay, I don't want to interrupt you. So the building permit says earthwork. Earthwork is not defined in your code. Earthwork and foundations. We looked it up, footnote 4 of our letter. Earthwork is not defined in the village code. Webster Dictionary defines earthwork, including excavation and embankments of earth. They issued us a violation for excavating. We were excavating. You have to prep, you have to survey, you have to prep, then you have to start digging. Yes, we didn't pour concrete. Yes, we didn't do rebar. We had 3 days. They issued us a violation the next week. None of that was able to happen. We started before July 19th. It doesn't say you have to start building your foundations before July 19th. It doesn't say you have to put your rebar in before July 19th. It doesn't say you have to pour your concrete before July 19th. You have to begin your construction work. We began our earthwork. We began the excavation, which the building department issued us a violation for. I'm not sure why we're even having this conversation. We want to build a huge project that's approved by all the boards in this village. We've spent a significant amount of money. We're ready to go. The building inspector, though, says, yeah, you can go again, but you got to pay the fee again, which is almost $400,000 they're asking from us. We've paid over $1 million in back taxes that were owed by the previous owner, building permit fees, because someone is saying, oh, you really didn't do earthwork. You did excavate, and we're going to violate you for that. But we don't believe that's construction work for the site. It seems like we're arguing over something that is so trivial. Stop. I've been a municipal attorney for over 20 years. I've never heard of a building department or a village pulling a building permit, arguing over whether we've excavated or starting to dig holes for the foundations. I've never heard of it.
Well, I
I'm
would,
glad
I
you
would,
asked about this.
I
When-
would mention this to the board in response to that. You had said that you began the work, July 16th, 19th at that time. And actually, the email that was sent to you was about revoking this permit was in September, which is essentially about 2 months after that time. So you still had your permit in place for those 2 months. Why wasn't the work continued on to start the foundation?
Jonathan, go ahead. You can answer that.
If I'll direct you guys to the July 20th report from our supervising engineer, who advised that we immediately stop excavation in deference to the safety of the Smith Robinson house. They were very concerned about the front porch roof in particular, it being unstable. And there's I don't know however many foot deep and thick concrete slab that abuts the north and west walls of the Smith Robinson house foundation, where we would need to do additional excavation. And the supervising engineer was very concerned that the vibration was going to translate to the Smith Robinson house and exacerbate an already unsafe condition. That's the supervising engineer's report from July 20th after he finished inspecting.
Which obviously does not have anything to do with this particular situation or what you are asking the board to interpret. But we knew, we made you aware of the conditions of the Smith Robinson house, which if those were concerns of your engineer, no measures were taken whatsoever to secure that so you can continue on with your permit. We had talked about having that front porch in the condition it was, in which it ultimately did collapse during a storm. We talked about the conditions of the building and the roof, and no measures were taken to secure it. But those are the reasons why we didn't continue on the permit for the construction of these buildings. But if you want to diligently pursue your building permit, then you would have went forward with making provisions to secure that building so that you can continue on with the permit that you did have, which went on into September, before it was determined that no work is starting. And with that, I mean, I'll leave that after this to the determination of the board, what they would like to do.
Jonathan, go ahead.
I think we very much did work to address the Smith Robinson house. We were in the middle of the process when the storm hit, and we have since completed all of the work in relation to all violations on the Smith Robinson house. The roof, the windows, the site safety, all that stuff's done. I just mentioned that more to illustrate where we're coming from. I know it's been complicated, but we did it.
We
Yeah.
can agree,
John,
we can agree to disagree with that, but that's okay.
That is not at issue, just for the board's, reference. The Smith Robinson house is not at issue with respect to this appeal.
This is a very narrow issue too. The question is, did we begin earth work prior to July 19th? What we did after July 19th doesn't really matter. Mr. Cluse indicated there was a stop because there was engineering issues that their engineer believed with the Smith Robinson house. The building inspector can disagree with that. That doesn't really, and most respectfully, address the issue of whether we began earthwork, excavation work, which you were violated for a week later, prior to July 19th. The evidence, the sworn affidavit says it was. If some off the cuff conversation occurred with someone on a excavator of what that person was doing out there, some laborer, to me, not an issue. He signed a sworn affidavit here, said he was performing excavation prior to July 19th. That's the issue.
The only issue I would say with
we
that,
want
he's
this.
he is not registered as the contractor.
So can I finish?
Go ahead.
But when you were speaking, you said, don't interrupt me. I'm just
I
trying to say.
didn't interrupt you when you
just
made
did.
your presentation at all.
You
Go
just
ahead,
interrupted me
you
now,
can
and you're
speak.
continuing to.
Go ahead, you can speak.
Thank you. That's how straightforward this issue is. We want to build this. We're looking to start building again. We can't. The village won't let us for some reason. I don't know why. They're trying to get more money out of us, and we just paid them $1 million. It's not fair. The urgency of this to build this right now, especially at this time, right before the winter, we won't be able to do some of this work with the winter months coming. We want to move immediately. We're again, there's $34.5 million of investment in hard costs into this village. Construction jobs are being impacted during a pandemic. We want to move forward. Honestly, I've never seen in 20-something years a permit not being able to someone to build when they have all the approvals, all the plans have been reviewed, we're ready to go, and some reason they're going to revoke the permit. It's very troubling to us.
Okay, so all I can say is it would be the determination of the board. If you feel that moving around some piles of debris that was left behind and pushing those into various piles and clearing out whatever number of weeds or whatever on site is considered earthwork and part of the construction of these buildings, rather than actually digging to put in foundations and start actual construction of the buildings, then the board can make a determination if they feel that the building permit should be still current. If your interpretation is that what was performed and what was done there, mind you, by the contractor who submitted an affidavit, who is not registered as the contractor on the permit because he did not file any insurances, any documentation as the contractor doing the work with regard to the building permit, then that would be up to the board to make a determination if they feel that this is what was accomplished and what they've seen is done on site there is part of the construction, then that's a determination they have to make.
That is a distortion of the record. It's not moving weeds and cutting weeds. His building inspector, his code enforcement officer issued a violation for what? Excavation. Excavation is earthwork. So we didn't cut weeds and move things around. We excavated. His own guy swore under oath that there was excavation there. They issued a violation for it. We're addressing it. We have to. That's why I showed you that.
So
Okay.
I want to
on purpose.
I apologize. I just want to jump in real quick. Chair, you have a hand raised from one of your board members. You may want to give Kyle an opportunity to raise his questions.
Kyle, go ahead.
Thanks, Mark. There's two things that keep coming up that keep being stated differently by both parties, so the village and Mr. Shafzada. I don't know if I'm saying your name correct. You keep saying it happened a week after July 19th, but the violation was in September.
No, the violation was sworn to on as part of the exhibit.
There's a difference between
August
the
4th.
violation that was received from Greg Gross, who's a code enforcement officer, and the revocation of the building permit, which was done by Joe Agostino. So that was the building inspector revoked the permit. Greg Gross is a code enforcement officer who wrote the violation.
The violation was issued on August 4th by Mr. Gross, swearing to the fact that earthwork occurred on the property and holes are caused by excavation work. He wrote it. He swore to it. I didn't write it. His own village official issued a violation for excavation on August 4th.
Amanda,
Week and a half after we began work. 2 weeks.
Amanda, can you pull that up, Amanda, or whoever, or Jaime? I'm sorry.
I think Jaime had it.
Sorry.
It's Jaime. It's exhibit.
Which exhibit is it?
Yep. Give me one sec. Exhibit 9. So towards the back, Jaime.
Yeah.
Probably about 430, page 430 or so.
I don't even think it's that far. Yeah. Which page is it?
It's 5 of 11 on the violation.
All right, here it is.
I'm not seeing it, honey.
This is 5 of 11 right here. Oh, I'm sorry, I'm not sharing my screen, that's why. That'll do it.
There it is, second sentence. There are holes caused excavation work. There's a word missing there by him. And that's sworn to on 8/4 with a court appearance on 9/14. The sworn to document is later in the pack. Signed by Mr. Gross. Page 11 of 11. You just.
You screw up a little bit, Jaime? Do you mind?
That's it. This is a signature right here.
No, I know, but could you scroll up a little bit? Just, yeah, okay, thank you. Thank you. What's the relationship of PE Consulting to ASF? Are they a subcontractor or?
No relation. Just to clarify a comment from before, JDA is a subcontractor of ASF, which is in the JDA affidavit. ASF is the contractor on the permit, and JDA did the excavation work, and the JDA affidavit states that they're a sub of ASF.
And they have the permit. ASF.
Darius, can I just chime in with something?
Sure, if the board.
Board, do you mind? I haven't said anything yet. Good evening, everyone. I just want to make sure that everybody listening tonight is aware of the history of the site and our involvement as the owner, because I know there was a question earlier, which is sort of irrelevant to maybe the determination and the specifics of whether we met the deadline or not. But so we were originally a lender to the prior owner. We didn't purchase the site for the purpose of developing it. We made them a loan while they did all of their pre-construction work. And the plan was they would get their construction loan and repay us, and we would go our merry way. They were not able to put together their full financing, and we ultimately took over only as of approximately November 1st. So it was, as a lender, as you can imagine, going from being a lender to being an owner, we had to, there was a bit of a learning curve to bring ourselves up to speed, assemble the appropriate team, prepare to actually commence construction. We also we're dealing with COVID. So I just wanted to point out that I think that, we clearly knew that we had the deadline to meet. We were focused on meeting it. We were very confident that we were doing what we were supposed to do. And I just, because there was a question earlier about kind of, why you've seen things for years without any action, but that inaction was before we became owners, and we've actually been, we think, quite proactive since we've taken over. Certainly acting in good faith with the spirit of trying to move the project forward. So I just want to point that out as the board considers all of the facts that we've presented. Thank you.
Go ahead, I'm sorry.
Go ahead, Ivan.
No, I was just gonna say, I mean, you have a couple of steps right here in front of you. I want to remind the board, you don't have to take a vote tonight. If there's still a lot of questions you're trying to understand, if you'd like more time to go through the materials, if you need a separate advice of counsel session prior to moving forward, you still have to open up a public hearing, which you can do today, or choose to hold off to a future date if you're not going to make any decisions now. So you have a lot of options ahead of you. I think that you've gotten a lot of information here tonight, but we do have another matter in front of us. It's 9 o'clock.
Yeah.
So,
So at this point, Jaime, I was going to say, unless there are any other questions from Kyle or George, I'd like to entertain a motion to open up a public hearing.
Second.
So moved. Or was that your motion, Mark?
No, he can't make the motion. He needs a motion.
Oh, great. I moved to open the public hearing. Kyle Beckley.
George?
Oh, yes. Yeah, second.
Okay.
Okay. All right, so that was Kyle open and then George second. So if there are no objections, wait to see if there are any objections. If not, then the motion passes by unanimous consent and we'll open the public hearing. Jaime, are there any raised hands or any participants?
no raised hands and no emails.
Okay. Well, then at this point, Amanda, unless you think otherwise, and based on the comments and the questions that I've heard and the complexity of the matter, I think it would make sense to adjourn the public hearing to a future date to have more time to consider all the documents, because there are many as this. So if that would be okay, I'm going to entertain a motion to adjourn the public hearing to the December date. I don't know when that is exactly, but
To adjourn to your regularly scheduled December meeting.
that's correct. Yeah.
If that's, I think that's reasonable given how, the size of the record, if that's how you feel.
I would say so moved, Kyle Beckley, but also so that we don't preclude our actual chair from having the option to research with us or on her own and then coming to the discussion next month.
That's a fair point too.
So I move that we adjourn the public portion of the meeting for our regularly scheduled December meeting.
Second.
And if there are no objections, then the motion passes by unanimous consent. Excuse me. Okay.
Thank you for your time. I just want to say every day that passes is a severe financial hardship here. We need to move this along. Our project, we're ready to build. We didn't ask you just to look at the facts and would show, we think clearly, that we began our excavation work, our earthwork, and we're ready to go. We're ready to invest a lot of money in this village. And we'd ask you just to consider that in the timeliness and the urgency of moving forward in the financial hardship this is causing.
Thank you.
Thank you.
Now, do you want to take a motion to adjourn the application?
Yep. So I'll entertain a motion to adjourn the application.
Second.
So moved, Kyle. And George.
Okay. Kyle, George can butt it out. I think it was Kyle first and then George. Yeah.
I think George was seconding.
So, and I think, can we do that by unanimous consent as well?
That's fine.
Okay. All right. Thank you.
All right. So the application is adjourned.
Yeah, and we need Bob Durayo back now.
Right.
Thank you for your time.
Thank you.
Thank you.
Nice, thank you.
Coming right now. All right. Sounds like baloney, right?
Hello,
Hello, everybody.
I am unrecused.
Hi, Bob.
Hello. So, let's see, where was I? Where were we? We are now up to, I believe, 24-2020 70A Croton Avenue. This is about an area variance for the rear yard, side yard, and maximum building coverage and also minimum parking aisle width. Jaime, could you describe where we are on the application?
Yeah, so the applicant has provided a lot of updated material, supplying with the full information of the side yard and rear yard setback. So going back a little bit on this application, the applicant had an approval to build a building that would have some retail on the bottom floor and have some residential properties above, along with a interior parking garage under or on the bottom level of the property, as well as a parking lot, surface parking lot, that had at the rear of the parking lot a retaining wall holding up sort of the earth behind it to the back of the property. That area, when it was uncovered, was considered a surface parking lot and therefore had different setback requirements than what a building would have. Because they enclosed it with patio, that patio turned that what was essentially a parking lot before into a part of the structure. And so because it was part of the structure, it was subject to all the same setbacks that the building would be required to adhere to. We've asked for a significant amount of information and been working with this applicant. They provided all the details telling us what the final setbacks would be for this property based off their updated as-built survey. And so we do have the details on that fact. There's one complication to this project. We have received recently some information regarding the engineering of the site, and there are some concerns about the engineering that would preclude the building from being able to get a C of O, or not a C of O, but I'm sorry, getting back their building permit, and could potentially alter the size of the building. So we're urging caution to the board here to certainly listen to the applicant, because we don't expect that the variances are going to change much, but they could change in light of the details that we just received from the engineering review that we had done on the property.
I have a question for Amanda. Given that they just received this engineering report and none of us have had any time to review it, might it be a wise idea for us to adjourn this to next month to allow us to find out what it says and what effect it will have on their variances?
Well, I think that, it is new information actually for everybody involved, but I think it would be helpful to have the applicant who's here, at least maybe try and answer the question of whether or not this engineering information, from what they can tell at this point, could have an impact on the variances. Could they answer that question now? And, have you specifically, you can specifically ask the applicant to look at that and provide you with that information for a future meeting. So I think you should take this opportunity to ask for that analysis to be done, and make sure that is going to be brought to your attention coming forward in the next meeting. I think you should at least give them a few minutes to describe any sort of.
All right, I think that's a reasonable thing, but I think Mark has something to say. Mark?
No.
Oh, okay.
Yeah, and I just want to note before we bring them on that there are 3 variances that are being asked for, not 2 that I had mentioned. So one of them is the one side yard setback. They need a 7.8 foot one side yard setback. They have a rear yard setback. They're required to have 20 feet. They only have 10, so they're going to need a 10-foot setback for the rear yard. And then they have exceeded the maximum building coverage, but not the maximum impervious coverage. So the maximum building coverage is 50%. They're at 62.7, so they need a 12.7% variance, but they are under the 80% impervious coverage. And that's that one also is because of the fact that when it was just a parking lot, wasn't considered part of the building, and therefore it wasn't impacted by the building coverage question. And now because it's a roof patio on top of parking lot, the parking garage, it is. So
I think, Jaime, are they also going for that driving aisle width? Yeah.
There was a question about the driving aisle. So there was some measurements provided that said that the driving aisle was on 24 feet according to their calculations. However, we had a review done by Keller Sessions, and they sort of scaled the project and did their own measurements, and they found that they were slightly under. So it's one of those things where it might be best, since we're dealing with all the other variances now, to have that variance tied in so that in case they needed in the future, they would be able to get it. It was only a small variance in terms of the aisle width. I think they were like 23.5 feet and where they needed 24.
Okay. So I guess the next step is to ask the applicants what they have to say.
So we have JB Hernandez here. We have Bob Corky here. We have William DeVore, Bill DeVore here as part of the application. And then we have Andre Fernandez here. And I want to say Arlene Clark is part of that, but I'm going to wait to let them tell me if that's correct. JB, is Arlene Clark part of this application as well?
Not that
Okay.
I think so. I'm not sure.
Okay, so Bob and Andre, you're
attendee. I think she put a chat up. She said no.
no. Okay, thank you.
You did ask whether 70A will be up next month, but I think, we're handling it right now to a limited extent. So that's the answer for her.
Okay.
Okay.
Just wanted to, I think Jaime did a good job of summarizing where the project stand and how we got here. I just want to point out to what the point that the chairman was making, that this is the existing rear yard is an open parking area, and it's surrounded by retaining walls. And that's once it became covered by the patio, that has been, is what precipitated the need for the three variances, because it became part of the structure. None of these questions that came up during the structural report that we received today, and it's not the final one, as I understand, none of them will have any impact on these existing retaining walls that are covered by the patio. They will not have an impact on the footprint of the building or any change on the interior of the building or what is going to be built. These, again, the variances are only required because the parking area, the rear, has become a part of the parking structure. So we are, the way we're looking at this, that the variances for the coverage, the variances for the side and rear yard. And I don't know if I can share the screen, Jaime.
Yeah. You gotta make sure that you're only providing detailed images that you provided.
Yes, Jaime. Yes.
Oh, you can. So
go ahead. You want to share your screen, Jaime?
Yeah, I'd be happy to. Yeah, I can pull anything that
share
we
your
have.
screen on the way. There's no issues with any information that we're providing. Because there is none. I mean, it's the same information, but so if you can share the screen, and you will see that this was a mixed-use building, 12 apartments. Nothing has changed in that. There are changes with, architecture review board, but no changes that implicate the reason that we're here today. If we continue down on the pages, this area, if you go back up one page, please, you're going to see that in this page here on the top, you will see that the area that's highlighted, which was an open parking area, when that became a patio, because we put a cover over, that has become what requires the need for side and rear yard variances, and also the coverage. In the next sheet, we show the coverage area. This is when, we had to calculate for the zoning variance that we became 67% of the coverage of the lot area. And that's therefore we need that. We will appreciate if the board entertains the notion of granting these variances so we can go in front of the planning board. Before we go in front of the planning board, we're hoping to have time to answer any structural questions that may come up. We had structural questions before, and did not change the building footprint before, and did not change the building structure before. So this is like in the process of getting any building permit, any construction drawings. There are questions that can be addressed, and winter is coming, and we would like to see if we can continue with this work and get this planning board approval. And we will appreciate if we can move this ahead and grant these variances. After the driving aisle width to be in 24, we're very comfortable that we can achieve this on the site, but it was recommended to us that we can, if you can continue down, you can see the patio, the rendering of the patio, that the aisle width, we asked for a variance of 6 inches to make sure that the aisle width comply. Either way, that variance, we don't feel, this is the patio, we don't feel that it's required, but in order to prevent any future issues, we are requesting it as well. As you can tell, this you see the patio.
JB, it looks like you froze.
That we're proposing. If we don't have that, this patio here, it will be not only will be enhance the use for the tenants of the building, it will also be a benefit for 70 Crown Avenue next door, since this is they're not be looking into an open parking area below. We're looking into a patio, and also preventing to have railings and any issue with car from 70 Crown Avenue coming over or falling into that. So we feel that the expense that our client has gone into to create this patio, it not only will benefit our building, it also will benefit the neighborhood. And I don't know if Mr. Corky has anything to add to that.
Yes, yeah, thank you. Good evening. Just one point to start with. There was a letter that was received by the building department from their consulting engineer, and I think Mr. Agostinelli can verify this. The engineer did not have the final plans to review that were prepared by our structural engineers. The letter that was received referred for some reason to prior plans that had been corrected in response to building department questions and suggestions. So the fact that this letter raised questions, it raised questions not on the plans for this building, but on prior plans. I'd also like to say that the structural engineer first reviewed this, and I think it was in March and April, and we've been waiting for his final review, and it just came the last week, and it was incorrect. So holding this up now for a structural engineer raising these questions seems to be somewhat untoward. Regarding the work that's done there, and I can defer to Mr. Agostinelli to verify this, these retaining walls in the rear, side yard and rear have been installed now, I believe, since February or March. They were approved under the prior site plan. They're there, they're extensive large walls. I don't remember the exact height, but they're extensive walls holding back the sides and the rear of the building. They're not going to move, and I don't know what engineering report would do to those walls. They've already been approved. As to the footprint and the foundation of the building, that again has been poured and been there now for 8 months, 9 months. So that's not moving. The reason that we have this issue of the requested variances is because earlier this year, the contractor mistakenly, I guess would have to say, went forward and misunderstood that he could do and put this patio on top of the retaining walls. It was an enhancement and an improvement to the building, but it had not received the final permit to do so. It was done under supervision of the building department. The pour was supervised, and it was not done clandestinely. It was all done with notice. However, that patio changed the way that the site was reviewed. As Mr. Martinez mentioned, the patio on top of the retaining walls led this to be considered as part of the structure rather than just a patio behind the building. And because it's the structure, we now have the required setback. Were it not for the patio, the walls would not be moving. The walls aren't going to move in any event. The rear yard setback, if you looked at the drawings that was just shown by Mr. Hernandez, only really is for the southwest corner. Otherwise, you notice it's a triangle in the back. Otherwise, there's more than adequate space there. So the real issue is to have the patio be in compliance with our code and not the walls per se. So there's not going to really be a change to the site or any change that we could do to the site, but we want to make sure it's in compliance. It is a terrific enhancement to the property. It's an enhancement both for the tenants and, as Mr. Hernandez said, the people up in 70 will not have to look down 3 stories and see a parking lot. As to the issue of the parking space between 24 and 23 and a half, I don't know if it was a field measurement taken or those measurements were taken off the plans. If it's off the plans, we'll ask for the variance. It may in fact be 24. We don't really know. I don't think it was done off the actual structure, but off the plan. So the area that the variances that were
Measurements were done off the plans, yeah. They were done off of what we had submitted to us.
Yeah, so the variances that we're looking for aren't going to change the footprint of this property, aren't going to change the location of the walls of the property. What it's going to do with the variance is just bring it into compliance with code, and that's why we're here. We would really not like to hold this up because, as I mentioned, the comments by the engineer, and I asked Mr. Agostinelli to verify this. It's not my. He didn't look at the right plans. And
Yeah,
actually, Joe, can you please speak to that?
Yeah, yes. We emailed the plans to him yesterday, the most updated set of plans. When we first hired him to review them, we had the plans that he had were the ones that we had at the time. And those were the plans that were sent also to the third-party reviewer. And then after the reviewer gave back his comments, which I believe there were whatever number of comments there were, that's when your design team created another set of plans. But those plans addressing the comments of the third-party reviewer were not issued to the engineer. But he has them now, and we should get a shortly in the near future, we should have an updated response from him that we can provide after he's able to review the plans and update his report.
So Joe, can you, before you talk, Bob, Joe, can you talk about the calculations? Because I know that in the conversation with Mr. Macri today, there was an issue about the calculations not being supplied until very recently.
Yeah, and that's the other thing. The reason what delayed him from being able to provide a report was he had requested that the engineer that drew the plans to this project provide calculations that he needed on how he created the design that he did. And he was not going forward on making the report until he was able to get those. So once they were provided, we had given him that, and that's which I think happened maybe a couple of weeks ago, a month ago. And that's when he proceeded to go forward with doing the report.
Yeah, and I want to state, just for the record here for the board so that you understand, we do have what we need from JB. So the architect has provided the details on the variance here, but the problem is that there are concerns that were expressed by the engineering consultant that some of the changes that or some of the elements that are missing from the plan, some of the concerns that they have may require changes to the structure that could result in interior changes such as loss of parking, change from the size of the wall.
Okay.
And
Question.
so we just don't know that.
Yeah, this is Andre. Can you guys hear me? I'm the owner of the project.
Yes.
Okay. And first of all, we sent you the plans in July, Joe, and the calculations to everybody. Today is what? November, no? Okay. You guys
That actually is not the
Joe,
case.
let me talk.
You
I
can
know you
speak,
guys,
but
let me
that's-
talk, Joe. Can I
That's
talk?
not the case because JB will be
Okay.
able to tell you when the plans were created.
Man, okay, I can send you an email today. I can finish the email. I can send you exactly to the boards and everybody when we finalize the calculations. You send you the plans. My concern is very disappointing to this point with you guys all because you guys stopped me the job in March, and this is November. I know you guys been playing games back and forth here because this letter, I don't know who sent it, just got yesterday to our information. And now every time, and I have everything on record, every time we go to a meeting like this, we have a letter coming up. Okay, let's push them to another meeting in another month. We've been like this from May up to now, and nothing's resolved. I got $2 million in material there, nothing resolved. And now you've been saying the walls are the walls. It got inspected by an engineer and approved third-party inspector. And Joe, you know, and you walk on the river, the decks too, and you know, and you saw that, and your assistant saw that too. And I have the reports. We have a meeting, me and you, we sign and everything. You were okay, done.
Okay,
First of all,
Andre, before you
let me continue. Let me
can
continue
you-
because I want to put everybody to on board what's going on over here. Second, then you stop me because I did a deck, I did it, whatever, because I don't have the breach. Okay, now this is March. Now we are in November. And this, you have your calculations, you have everything on you. And it has nothing to do with variance to a variance in the little wall. I'm doing improvement. I spent $200,000 to do a patio for my people live better in the building. For have some amenities before you used to have a parking lot and it's got to jump through. It has no, see that patio over there? It's a hole. Okay. And now I understand why we're going to push. I see the board member said we got to push another month. Listen, guys, I spent $2 million like land acquisition and material, spent $2 million up to now. 8 months waiting for you guys. I don't have no.
Sir, I'm sorry, I have to interrupt. You are leaving out the fact that the reason that you're in this position in the first place is that you constructed improvements to the building that were never approved by the planning board. You constructed the patio and other, there were changes to the building. Please don't interrupt because you need to be corrected. There were improvements to the building that were never approved by any board. You constructed improvements that were totally off plans. Hence, you're in this position because of your actions. So we are now taking the appropriate action to make sure that the building that is half constructed is safe to be lived in. That requires thorough review by structural engineers. That is still ongoing.
We send back and forth emails from June up to now, and you guys are pushing and pushing back. Why they send the wrong plans? By the way, why they send the wrong plans to the review?
Let me just make this very clear. Mr. Cork and Mr. Hernandez are aware when the timeline is when they've submitted the documentation that was required.
I can send it.
So yes, they're well aware of that. If you're mentioning dates that you're under the impression of when those actual plans, the actual final plans for review that are currently in front of the engineer.
We're talking
Actually,
about the
construct-
engineering calculations and engineering calculation for the structure, okay? Engineering calculations for the structure, this is what I'm talking. And engineering calculation and structural drawings, non-final plans, because we are prohibiting to this continue forward with a variance because of the structure, and it's wrong, because you have that 4 months ago.
No, that is actually not the case. I'm not
I
gonna
send
allow you to
emails.
make
I'm not gonna
statements
go
that
around
are
the
not
country
true.
more on this.
Your attorney and your architect are aware of when these documents that were needed were provided. They were
No,
not provided
I-
4 or 6 months ago, as you.
All right, so before we move any other conversation on this, the zoning board has an application in front of it regarding variances. It is staff's recommendation that you do not take a final vote on this today. However, that does not preclude you from having a public hearing on this matter, does not preclude you from asking questions about the variance. And I think that we should, rather than having a back and forth on the calculations, to deal with an engineer's report, which need to be dealt with prior to the issuance of any new building permit, prior to any CO, that's going to happen. So we're recommending that until we have some clarity on that, you don't take a vote, but you can still do quite a bit. And I would recommend that the board take the opportunity to do that.
Kyle has a question, so I think we should hear from him.
I have a very simple question that I'm going to ask Jorge, Robert, and Joe. And it's a one phrase answer, and it's a date, and that's all I need. Joe, when did the planning department, or when did your office, Jaime's office, receive the current or the engineering plans with the patio? What was the date?
Well, no, the original, there was plans that were submitted for patio, right? But those plans went to a third-party reviewer because the scope of work changed from what was originally. The original on this plan was supposed to be that the second and third floor was supposed to be a modular. That's how it was presented when it was previous owner. When Andre bought this property, that was still going to be the scope of work, that they were going to do the foundation walls and put a modular on it. And somewhere midstream of construction, it changed from a modular building into what we're seeing now, a full concrete steel building. So the building was being advanced into the second floor without actually having any plans of such for the construction that you're seeing is happening today. And that is why he received the stop work order, because we did not have the plans for the construction going forward. It was presented as a modular building, and Mr. Hernandez can attest to that. I believe Mr. Corky is aware of that. So this was stopped because the type of construction that was going on beyond the first floor was different than what was provided to us. So
great. So the current plans that you're using based on the new design were given to you when?
I think, Kyle, if I may answer, think that I believe that the date of those plans was August 20. The latest revision that we submitted for the structural engineering that the structural engineer submitted, they're August 20th. I believe that after that, there's been slight changes, but the drawings that we're talking about that the engineer should have been reviewing were dated August 20th.
right, and those plans, what occurred is those plans were sent to they were in response to the third-party reviewers' comments. They were sent down there for review, and it took a number of weeks before we got his response back. And then the engineer who was preparing the report was requesting in the meantime to get the calculations from the engineer, which was provided, I believe, maybe about a month ago, and that was sent to him. But the error that we had in this was from the time that he received the calculations, he did not get the updated set of plans originally when he did his report, which was done over the last week or two.
Yeah, and kind of to give a little background to this, because we didn't talk about this before. It's been in front of the planning board for some time, but it's just coming to the zoning board now. The reason there's a structural engineer involved in this process is because there's a large crack in the patio pavement, a patio concrete that stretches from one side of the building all the way to the other. And so that looks, disconcerting, I think, to the average person. I want to just let me finish. It looks disconcerting to the average person which is why a structural engineer is needed to come in and evaluate why that's there. And so in the discussion today with that structural engineer that we have that's reviewing this, they're concerned that the crack may be related to larger issues than just it being a small piece. It may be related to something that would require some additional shoring up of the retaining wall. And that is the reason why we are asking for the board not to move forward. Again, that's only with a vote today. And they have submitted materials that are related to the variance. And so the board, obviously has the ability to do what they want to do here, but I would highly recommend asking questions about the variances that are in front of you, opening the public hearing and getting into details about that. The material that I want to correct something. I don't know that the calculations, which were the main reason that was holding up the final comments from the structural engineer, those calculations I don't think came back in August. I thought they came back.
No, they actually were provided with like about 4 weeks ago.
Joe and Jay.
Those were the calculations are how they, again, I'm not an engineer, so I'm going to speak about this really poorly, but the calculations are the way that they determine whether or not the structure is holding up the ceiling correctly. And there were concerns about having only some calculations available to them. What was mentioned today, that there were no lateral calculations provided. So he has questions about the retaining wall itself and whether it's capable of holding up.
Why? Okay, Joe.
I'm not an engineer, so if you're going to ask an engineering question,
hold on. Now I'm going to ask
I can't answer.
I'm going to ask Joe. This is wrong, and you guys, it's wrong because of this. We send you calculation. I can prove. We send you calculations up to the first floor. You see where everybody drives by the site. You see whatever is put. I send first. We send a calculations up to the first floor, whatever is done now. We send report letters from my engineer, stamp letters, everything before. And JB, tell me if I'm wrong. When the new
That's not the issue.
That's not the issue before. If I can make
the calculations, okay, you're talking about two different things. The
Yes,
new calculations from the patio up, from the first floor up is one thing, because the plans changed a little bit. You guys added the stairs, extra stairs. This is why the structural plan changed. The structural plan never changed from March.
No, but let me
whatever is done
Andre,
inside
let me
never changed.
explain to you to clarify this. It's not so much maybe the retaining walls and the work that is done. The engineer who's reviewing it is also reviewing the fact that now that we're going up to the second.
Plans for March.
Let Joe finish. Stop interrupting, sir.
Okay. The plans that are being built now with the second and third floor require supports, certain columns in certain areas and so forth. The question that he's looking into right now is that a lot of these columns land right on the slab of the second floor without having columns below them transferring the weight all the way down. So he's doing an analysis right now to find out what has not been constructed yet, but is proposed on your plans, if it's actually done properly or needs to be modified for additional amounts of support. It's not necessarily what was already done, but what you are preparing to do that's being reviewed at this point.
But
if you let me finish, the modifications that may need to be made may not affect the zoning variances at all, but it has a possibility. It has a possibility that it may. So until that report is read by your team of people, your architect, your engineer, and to make a determination on how they want to proceed going forward and what modifications they may make is the only way we're going to know what we're going to do going forward. And that's why I said to you, that report will be provided according to the engineer in the short term, maybe by tomorrow. And then you will be able to make a determination of what needs to be done to, if there is any to be done, to rectify what changes may be needed. They may not affect the variances that you're proposing, and they may, depending on the path that you take once you receive that report.
Why?
Can I say something?
hold on. Hold on a minute.
All right,
You've
can
been going
I?
round and round over
Okay.
the same thing over and over again. I understand, sir, that you have concerns about how long it has taken. However, that's not what we're talking about this evening. I appreciate it. It's on the record. Going over it more is not going to solve anything. What we have to determine tonight is, do the variances you're asking for, as you're currently asking for them, are they to code and are they reasonable? And in order to do that, first we have to get input from the other board members really quickly, then open a public hearing, see what the public has to say, and then this board will decide whether or not we need to wait until we get the results of the mitigation required after we get the study back from the structural engineer. And that's what has to be done now. Going over and over again, the same information isn't helping you. And it's only, it's not productive.
I'll make
Know
mental
what you
waiting.
need.
I'll make mental waiting.
What's that?
Okay, you should.
May I say something? I'm
Understand,
sorry.
we apologize for the long wait, but sometimes putting in the time now, look, there's a building near on my corner, okay? And a retaining wall collapsed because, and now that building is not occupied, okay? Now, I wasn't on any of the boards then, and I'm not blaming anybody, but I assure you, if they had, maybe if they took more time and looked at it more carefully, that wouldn't be there. So we're doing this for you, for your new upcoming tenants, and for the people who live here. We want to make sure that you, at the end, you get a building that meets code, safe, right?
Yeah,
That's safe.
they're killing
and good for everyone.
the job. They're killing the job. The way they're killing me. I got $2 million invest over there.
We know, here you are again, you're saying the same things over and over again.
Reason, and this is what I'm saying is this, the plans, I can send an email a copy about it today.
So again,
I'd like to suggest that we motion to open for a public hearing or adjourn the public hearing because we are not getting new information and safety of individuals in the community.
No, yeah, and I'd like to hear a motion. I'd like a motion to open the public hearing.
May I say one thing?
I second that, Kyle.
Great.
May I say one thing?
If you want me to mute everybody else, I'm happy to do it.
Yes, please mute this guy. He doesn't understand decorum, and that's something coming from me. So we're going to open the public hearing at this time. Jaime, are there any people here to speak on this project?
No.
All right. Is there any correspondence from the public on this to be read?
No.
No. Then at this time, I would like to make a motion to adjourn the public meeting because we're not done with this till next month.
So moved. Mark.
Second, Kyle.
Okay. So at this time, I'd like to have a roll call vote on closing this public hearing because we're dotting the i's and crossing the t's.
Hold on. I apologize. There's adjourning the public hearing and there's closing the public hearing. I would recommend adjourn the public hearing.
Yes.
And you can adjourn the matter until next month.
Correct.
I would like to do that separately. So you're doing a motion to adjourn the public hearing.
Right.
And you can do that through unanimous consent. You already have a first and a second.
Great. Anybody have a complaint? Then yes, we have unanimous consent to adjourn the public hearing. Now, we need a motion to adjourn this application to the next meeting. Is that correct?
If that's what you'd like to do, I think
That's what we'd like to do. I'd like a motion to adjourn the whole thing to the next month.
So moved.
Bob Corky, if you have comments, you can certainly submit them to the board in writing.
Yes. We need a second.
Second, George.
Great. So I'd like a roll call vote, please.
Bob Durayo,
Aye.
Kyle Beckley,
Aye.
George Bailing,
Aye.
and Mark Gorechny.
Aye.
And having unanimously voted for this is adjourned till next week, next month.
Next month.
Do we have any other?
You
anything else?
have the minutes.
Okay, we need a motion to approve the minutes from last month's meeting.
So moved, Kyle.
Was everybody there? I don't recall.
I believe so.
Yeah, you both were there.
George should
Oh.
not vote.
George was not, yeah, George.
Yeah, so,
So you need the three of you.
We need three, so.
yes, so Kyle,
Motion to approve the minutes from last month's meeting.
Second, Mark Gretchen.
seconded by Mark, roll call vote.
Bob Dario,
Aye.
Kyle Beckley,
Aye.
and Mark Gorechny.
Aye.
Is approved by unanimous consent. What's next?
That's it. That's all.
Ladies and gentlemen, I want to thank everybody for their patience and their time. I would like to particularly thank our magnificent staff who put in long hours during the day and then come here in the evening. And we really appreciate your time and your effort. Thank you so much. See everybody next month. Good night.
Thank you all.
Thanks to you guys for volunteering.
Good night.
Thank you.
Feel better,
Thanks.
Jaime.
Oh, thank you. Bye-bye.
Good luck.
So long.